You sued your doctor for medical malpractice, and now, 2 years into the litigation, the defense finally decides that they want to negotiate. And now they present an offer to your attorney. If you reject the defense's offer, is there any way for you to know whether or not, if you go all the way to trial and take a verdict, whether the jury will give you substantially more money than what's being offered now during settlement negotiations? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And the answer is no, there is no possible way for you to know what a jury is ultimately going to do when you go all the way to trial and take a verdict, and now are trying to figure out what's the jury going to do at the very end of the case if I am successful, and if the jury determines that you are entitled to receive compensation and receive money as a form of compensation. There is no possible way to know beforehand how much money they are going to give you for all of the harms and losses and damages that you incurred because of the doctor's carelessness. So now you may be saying, how do you actually evaluate the defense's settlement offer, knowing that there's no way to know what a jury's going to do? And that's a great question. So here's the process. Your attorney comes to you and says, hey, listen, I just got a settlement offer from the defense. Here's what they have now offered. Your attorney is going to go through with you the details of that settlement offer and then begin to explain to you the risks of accepting it and the risks of not accepting it. He says, listen, if you choose to reject the settlement offer and they tell me that there's no additional money being offered now you have to go to trial. Now you have to have a jury decide whether you are slightly more likely right than wrong than what you are claiming is true. And if the jury finds in your favor, now they will have to give you compensation. They will have to give you money as a form of compensation for all of the damages that you are claiming. You might have a claim for past pain and suffering and for pain and suffering into the future over the next 20 or 30 years. You might have a claim for lost earnings. So there are economic losses and there are non-economic losses. And now the jury will have to decide how much each of those claims are worth and ultimately decide, hey, this is how much we are going to give to you because of the doctor's carelessness. The reality is that nobody knows what the jury is ultimately going to do until they do it, right? So then how do you decide whether or not to accept or reject the defense's offer? Well, now you have to rely on your attorney. Your attorney will likely have done significant research to determine the true value of your particular case. He may tell you, listen, your case has a range, your value has a range of this amount of money. And if they're now offering this amount, there's a possibility that they will now increase their offer at some point before trial or even during the course of trial. That is a possibility. On the other hand, they may reach a point in the negotiations where they say, listen, this is the maximum amount that we feel the case is worth. We're not offering another dime. If you don't want to take it, fine. We're taking the money off the table, and now let's have a jury decide how much this case is worth. So how do you then decide whether or not to accept or reject the defense's offer? Well, you have to have a realistic conversation with your attorney. And by this point, your attorney should have done a tremendous amount of research to evaluate what the true value of your case is worth. And then he'll tell you, listen, your case has a value of this particular range. And now the defense has already offered this much. Let's see if we can get them up higher. And now he'll try and engage the defense in negotiations, but there may come a time where they turn around and say, you know what, this is our line in the sand, we are not offering a single dime more than this amount. At that point, you now have a decision to make. Do you take it, or do you risk it and now say, I'll take what's behind door number 2? You don't know what's behind door number 2. You don't know what's behind door number 2. It could be a big fat zero, you might lose your case, or you may get a small amount. You may get a huge amount of money, or you may get something in between. That's the problem with going to trial. Nobody knows what the ultimate outcome will be. Not you, not your attorney, not the defense, not the defense lawyer. Nobody knows what's going to happen when the case goes to a verdict. So you have to make an educated decision based upon the facts as they are at the time of the negotiations, and based upon your current needs and your attorney's perception and his understanding of the current case law, to help you reach the conclusion, an educated conclusion, about whether or not to accept or reject the defense's offer. So why do I share this information with you? I share it with you just to give you an insight and an understanding in what goes on in these medical malpractice cases here in New York. You know, I do understand you're watching this video because you have questions or concerns about your own matter. Well, if you have not yet started a lawsuit and your matter did happen here in New York and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.